Thank you, everybody, for joining us here today. We're here with Contesting a Will in British Columbia. It's Q&A with Amy Mortimer and Zachary Rogers. And we are really excited to have you here today. We had a large number of registrants. This is a topic we get a lot of questions about, and we're really excited to be able to share some legal information with you. Before we introduce our speakers, I know you're all super excited to meet them. Just like to extend our thanks. We'd like to begin by acknowledging that the land on which our team is gathered is the unceded territory of the Coast Salish peoples, and that includes the territories of the Squamish, Musqueam, and the Tsleil-Waututh nations. And we extend our acknowledgement across the province to those who are viewing remotely. We would also like to acknowledge our guests here today. So everybody who has taken the time to tune in and to learn more about this topic, we would just like to acknowledge you and to thank you for being here. You are the reason that we do these presentations, that we're really interested in communicating this legal information to you. And so thank you so much for being here today. We would also like to thank the Law Foundation of British Columbia. They are our primary funder and they make this type of presentation possible. And finally, we would like to thank our speakers, Amy Mortimer and Zachary Rogers, who we have the pleasure now of introducing. So Amy and Zach, they are both lawyers at Clark Wilson. They are leaders in the estate litigation area. Amy has very generously reviewed a number of the pages on our People's website relating to this topic. So if you go online, you'll see some of the pages that she has reviewed. It's wonderful. Amy and Zach also have recently created a book, but I don't feel like book is the right word for it. It is a book about the British Columbia estate litigation, and it's basically a manual created by practitioners, and it covers all the topics that we're covering today in depth. And so it is a wonderful resource for lawyers in our province, for anybody who's really keen on getting deep into the materials that we're covering today. That is a recent publication, and they have been working very hard on that. And in addition to their legal expertise, one thing that has really stood out in my conversations with Amy and with Zach is not only their willingness to help, to really jump in and do what they can do to create today's presentation, it's also their attention to the non-legal aspects of this very sensitive topic. The estate litigation matters tend to involve situations and conflict among family members, and they are really, as you'll see in our discussion, they really highlight that element of this area as well. So welcome, Amy, welcome, Zach. It is so, so great to have you here today. Thank you so much for being here.
Thank you, Paula.
Thank you. And so with our introductions, we would like to start by asking some of the common questions that we receive about challenging a will in BC. And often when we think of a will, we think of it as being the final word. So our first question, and Amy, maybe you can begin, is a will really the final word in BC?
Thanks, Paula. And thank you for inviting Zach and I to come and present to you today. And thank you to everybody who has taken time out of your day to come and hear what we have to say. And hopefully this can be helpful to you in your own lives and relevant to your own circumstances. But to answer your question, Paula, in the vast majority of wills in British Columbia, yes, it is the final word. Usually what happens is that the will go to probate and it will just be administered in the ordinary course, and there is no litigation. But there is a small section of wills where the circumstances are such that lawsuits are started. And that's what we want to talk about today. There are a number of ways that the distribution or the gifts that are set out in the will can be challenged later after death by the loved ones. And we're going to talk about 3 different ways. There are lots of them, but we're going to talk about 3. We're going to talk about undue influence, incapacity, and will's variation. Just as a bit of an overview, I'll tell you about incapacity and undue influence, and Zach will talk about will's variation. Incapacity and undue influence are two separate ways of challenging a will, but they often are pleaded together. They're often in the same lawsuit because the facts often give rise to a concern about incapacity and at the same time, a concern about undue influence, but they're different. First of all, incapacity. What that means is anytime somebody is making a will, you have to have a certain level of mental capacity, a certain level of cognitive ability in order to make that will. And so oftentimes we see it with people who have been diagnosed with dementia and they've got now some difficulties in the way that they can think and remember and reason. And so in those circumstances, it may be that even though they signed a will, and even though there was sometimes a lawyer involved, that will is not valid because they did not have enough of a understanding of the effect of a will or not enough knowledge of their assets and how they're structured and how much money they have, or maybe they don't have a good understanding of their loved ones. And as a result, that will be set aside by the court. Sometimes we have a different type of challenge called an undue influence claim. And in that, what it means is when you're making your will, you need to be putting your own wishes down on the paper. But what happens sometimes, especially again with elderly or vulnerable people, sometimes somebody else can impose their will, impose their wishes onto the will maker. And so the will that results does not properly reflect the wishes of the person who made the will. But it's as a result of this, we call it undue influence. It's too much pressure that's being brought to bear on this other person so that it does not reflect their true wishes. If the court finds that there was undue influence, the court will set aside that will. So for both incapacity and undue influence, if the court finds that one or the other is present, the will that was drafted will not be valid. And so that's two of the types of claims that can occur. And Zach?
Yes, thank you, Amy. So the third way in which wills can be challenged in British Columbia is through a wills variation claim. And it is one of the few provinces, BC, where a challenge of this type is still possible. And in the form that it exists in British Columbia, it's quite unique how we have it here. And I'll get into the reasons why later. In a wills variation claim, you begin with a will that is valid, so it doesn't have the features or may not have the features that Amy talked about just a moment ago, but perhaps a primary challenge or a secondary challenge to it is that someone is unhappy with the gifts that they've received in that will, or perhaps they have not received any gift at all from someone that they would otherwise expect to. So for example, you may receive a gift from a parent and your sibling may receive a substantially larger gift than you, and that might, you might take issue with that. And alternatively, someone may have been excluded entirely from the benefit of someone's estate, and they may take issue with that too. So with a will's variation claim, it is a challenge not on the validity of the will, but the gifts made within it. And it is important to know that the individuals who have the ability to bring a will's variation claim are limited to spouses and children. And for spouses, that includes legally married couples, legally married spouses, and common law couples. And for children, that includes biological children and adopted children, but it does not include stepchildren or any other type of informal parent-child relationship.
Excellent. That is so helpful. Thank you, Amy. So you have set up the first piece, which is the uninfluence of validity. And Zach, thank you so much for introducing this other concept, which is unique to British Columbia, I understand, this idea of being able to challenge based on the fairness. Did you receive what you should have received under the will? Let's turn this into, more sort of the concrete examples. So here's a fact scenario. Amy, my mother left almost everything to her caretaker. I think that she was taken advantage of. What can I do in this situation?
So this is a very common circumstance when somebody passes away, a parent passes away, and the child then for the first time sees the will and sees that instead of what they were expecting, there's in fact a gift, a significant gift to a third party. In this case, it's somebody who's not related and who is a paid employee. So the first scenario that comes to mind here is undue influence. And I'll tell you why. In undue influence, what we look for and what the courts will look for are what we call red flags. And so it's a type of circumstance that makes us say, let's make sure that this will truly is reflective of the wishes of the deceased and that there is no undue influence. And so these red flags are basically suspicious circumstances. And so in our example, a suspicious circumstance is that there is an unexpected significant change to the will made shortly before death. That's a red flag. That's something that deserves further investigation. A second one, red flag, is where the recipient of a significant portion, a significant gift under the estate is somebody who's not family and is in fact a paid caretaker. So that's going to be a second red flag. Another red flag here has to do with vulnerability. And so in this case, we know that the mother had a caretaker. And so that suggests to me that mom was either had some difficulties with her cognition or with her capacity, such that she's not able to be on her own and care for herself, and or she has some kind of difficulty physically. And so we see in this picture that she is in a wheelchair. So maybe she has some mobility issues. Maybe her mind is sharp as a tack, but she's got mobility issues. In either case, the fact that she relies on somebody else to help her do her daily living tasks, like going grocery shopping, getting her food ready, maybe getting up and getting dressed in the morning, getting to doctor's appointments, all of those types of things that it looks like she's not able to do because she has this caretaker that's come to assist her, that gives rise to a concern that she's vulnerable and that there's this relationship that has the potential to give rise to undue influence. Because if, for example, the caretaker was saying, you need to leave me something in your will, otherwise I'm not going to help you and you're not going to be able to stay at home, in your own home, you're going to have to go to a care facility. And if mom didn't want that, maybe that's enough pressure. And if it's exerted strongly enough, that might be enough pressure to change mom's will. And so that may be enough to cause the court to say this will needs to be set aside because it does not reflect her true wishes. So, as I say, the most likely, or the one that it first comes to mind when we see this little bit of a fact pattern, is undue influence. If the caretaker is as a result of some cognition problems, maybe some capacity issues, then maybe there's an incapacity claim. Maybe it's both incapacity and undue influence together. And then the other one that comes to mind in this scenario is that because it's the mother that doesn't leave as much of a gift to the child, we can potentially have a wills variation claim, which is what Zach was just talking about. So it may be that even though the court might find the will to be valid, the variation claim might be successful and the court would rewrite the will to give the child a larger portion and then therefore a smaller portion to the caretaker. So potential for at least three different types of claims. And so obviously, as we met with the client and did some more investigation, got more facts, we decide which is the best route for this family on how to proceed.
Wonderful. Thank you so much, Amy. It's such an interesting question. And, I think how you framed it is these red flags to look for, this late in life change to the will, the idea that this is somebody who is not a family member, this is somebody who is being compensated to care for the mother in this situation, and also to look for that element of vulnerability to assess, the circumstances in which this person was in at the end of their life, and would there be that element that might make them of the place to alter the will in favor of that person to maintain something in their life, their independence or whatever that might look like. So that's very interesting. And also this idea that one set of facts might give rise to different avenues to challenge the will. Maybe it's the undue influence aspect of it, or it could also be the capacity or the will's variation. So very interesting. Thank you so much. Zach, we're going to move into another scenario, and this time we'd like to ask what you think on this question. So again, dealing with the death of a parent, maybe somebody who wasn't living in the country, who didn't see their father very often. So this is a case where we have a father who's been diagnosed with dementia. And it turns out in the will, he left more to his social club than he left to me. And in that situation, what can you do about that?
Sure, thank you. So very similar to the scenario in which Amy just provided an answer. A situation like this highlights some red flags for me too. And so the first one perhaps is that father had dementia or some sort of a cognitive decline that would cause me some concern or cause me to question whether he had capacity when he executed this will. That isn't to say that anyone with dementia or cognitive decline or disabilities are unable to make a will. There's certainly scenarios where they're able to, but it at least causes me to question whether capacity was there and would cause me to investigate further whether, the circumstances surrounding the creation of that will, just to ensure that dad did have capacity in this scenario. Similarly, in addition to the capacity issue, we have a situation where a child has received very little benefit from a father's estate, possibly nothing. We're not entirely sure here. And so it also gives rise potentially to a will's variation claim. So we have this social club that may have played a very significant role in this person's father's life, but that does not necessarily justify a disinheritance or giving a substantially smaller gift to a child. And so that would be another perhaps avenue for challenging this will if the circumstances supported a variation claim being the stronger of the two between capacity and will's variation. So in terms of what this individual can do is first and foremost, file a notice of dispute. So a notice of dispute is a form that is available on the BC Supreme Court website that can be downloaded and completed and filed with the registry and any Supreme Court registry in British Columbia. And in filling out and filing a notice of dispute, it will essentially halt the administration of an estate that is in dispute. This needs to be done before a grant of probate or a grant of administration is made by the court. And so the earlier you do this, the better. I believe that's the important stuff for me, Paula.
Beautiful. Thank you so much, Zach. And again, very interesting to see how one set of facts can give rise to more than one type of claim, and how you have identified this red flag being that the father has been diagnosed with dementia, and that in itself, interestingly, may not mean that they lack capacity. Is that correct? But that it is something that would need to be investigated further.
That's correct. And maybe I could expand just a little bit on that, Paula. What filing the notice of dispute does is buy time first and foremost. So from there, once the administration of an estate is halted or the grant process is halted, you or a lawyer you're working with can really dig in and investigate the circumstances that gave rise to the creation of that will. And so that may be speaking with the lawyer that assisted with the creation of that document, or it may be speaking to the witnesses who witnessed the creation of that will. There's a number of avenues to investigate this issue of capacity, and filing of the filing of the notice of dispute is what creates the window of time within which you can do that.
Fabulous. So that's a very important piece for anybody who has those types of concerns then. So Zach mentioned this idea, and Amy did too, this idea of a will's variation type of claim that can be brought in circumstances where somebody who thought they would be benefiting from the will is not. And Amy, when the court is looking at that type of claim, what are the factors that would be taken into account in deciding whether or not to vary the terms of a will?
So the factors that a court in British Columbia will look at are different than elsewhere. And I think that's really the distinction here in British Columbia is we have a very powerful piece of legislation, and it has broader powers, I think, than it gives broader powers to our courts than some of the other provinces. And it includes, for example, the right of an adult independent child, so somebody that lives off on their own and has their own source of income, that person can still vary the will, apply to vary the will. And so that's what makes us a little bit unique. But it doesn't mean that everybody gets to vary the will. Not every will challenge or every will variation claim will be successful. And while every claim turns on their own particular facts, I'll tell you how the court will assess it. What will happen is the court will look at the deceased and their relationships. So they'll look at the spousal relationship. For example, is this a long-term spousal relationship such that all of the, from the time somebody was 20 years old until they died at age 80, such that all of their assets that are in their estate were built up during the course of that marriage? That's going to be a pretty significant factor. Another factor the court might look at is, well, that spousal relationship did not start until age 65, when the deceased had already earned their fortune and amassed all of their assets. And it was only, say, a 2-year relationship. And so would that have an impact on the amount that a reasonable person would expect the deceased to leave to that spouse? And so the nature and the length of the relationship is going to be very important. Still dealing with the spouse, sometimes spouses have marriage agreements that they put in place before they get married. And what it sometimes does is it talks about, especially if it's a second or later relationship or a later in life relationship, they may say, I'm going to keep my assets for myself and give them to my children that are not with this spouse. And then the other spouse says, I'm going to keep my assets and I'm going to give them away in my will to my children, and I'm not going to give anything to my spouse. So those are quite common nowadays. And what that means is, while it's not a complete bar, you can still apply, that spouse can still apply to vary the will. It's something the court is going to look at. And when the court is looking at that agreement, they're not just going to look at the agreement as of the day it was signed, but they're going to look at, did they in fact, over the course of that relationship, did each spouse keep their assets separately? Because if not, that's going to weaken the strength of that agreement, because even though they agreed they would keep their assets separately and keep separate bank accounts and pay for their own share of things, if in fact they did not, the court is going to take that into consideration in determining whether or not to vary a will. For the spouses, or sorry, for the children, children are allowed to apply to vary, either children who are not yet adults with certain procedures, and adult children. And one of the other factors the court will look at is during lifetime, especially if it's just a dispute amongst the children, what assets were given to each of those children by the deceased. And so something that we often see is that some parents are able to provide gifts to their children during lifetime at significant life milestones. So for example, sometimes the parent will be able to give significant amount of money to the child to be able to obtain a university education or some sort of post-secondary education. Sometimes the parent is able to provide a significant amount of money that can be used as a down payment for a house. And so if they did that for one child but not the other, then at the end of the day, on passing, it may be that the will gives more to the child that didn't get the gifts during the lifetime. And the court will say, well, is that fair? And it might be. So it doesn't mean, and this is an important concept, just because things are shared equally doesn't mean it's equitable, doesn't mean that it's fair. So what the court will do is look at all of the circumstances and decide, in all of the circumstances, based on all of the assets that this person has and had during lifetime, does this make sense in all the circumstances? And that's going to depend on each family. So we can't give you a definitive answer, but we look at different factors, and we can find different themes running through the case law.
Fascinating. So it really is a question of digging into the facts of each case, the circumstances around if it's the sort of partnership or the romantic partnership, what that looked like, what the relationship was with the children, gifts that predated the death. It's a very complex and factor-driven analysis in each individual situation.
It's absolutely unique to each family. And you're exactly right. It's just you need to investigate and dig into the actual facts in that family.
Fabulous. Thank you. Thank you, Amy. Zach, we've talked a little bit about we've talked about the factors that will be considered, and we touched on this earlier, but who has the right to bring this type of claim, this wills variation type of claim?
Sure. So the individuals who have the right to bring a wills variation claim are quite limited compared to the more expansive list of individuals who can bring a challenge to a will for other reasons, and I'll touch on those second. But for a wills variation claim, it is important to know that the individuals it is limited to are spouses and children of the deceased. And spouses, as I mentioned earlier, include legally married spouses and common law spouses. And what's particularly important and what we see often here in British Columbia is that common law spouses are individuals who lived in a marriage-like relationship for at least 2 years. It does not mean that they had to live together. And so a number of people believe, perhaps wrongly, that they are not in a common law relationship simply because they have maintained separate houses from their common law spouse. And so that is a feature we see often in estate litigation is trying to determine whether two individuals were in fact common law spouses or not. The other category that has the right to bring a wills variation claim are children. And as I mentioned earlier, that includes biological children and also adopted children of the deceased. That does not include stepchildren or any other individual to whom the deceased stood in a parental role. It really does have to be biological or adopted, legally and fully adopted, in order to have standing to bring a wills variation claim. With respect to the other types of wills challenges that we're talking about here today, generally the individuals who have the right to challenge a will are those who were named in a previous will document. In prior wills, if someone was set to receive an inheritance and that individual was removed for whatever reason in a subsequent will, that person has the right to potentially has the right, I should say, to challenge the newer will where they are excluded. And in addition, individuals who would, this is a legal term, so I'm going to explain it, but who would take on intestacy, so close family members who are either children, spouses, the deceased parents, the deceased siblings. There's a whole hierarchy of individuals who are close family members, and it goes out to, I believe, 4 degrees of not separation, but 4 degrees of hierarchy. Those individuals who are close family members would take on an intestacy, which means if the deceased did not have a will, those individuals also have the right potentially to bring a challenge to a will for a variety of reasons.
Excellent. Thank you so much, Zach. And I think that point you made about the common law spouses not having to live in the same residence, I expect that's something that would be surprising to a lot of people and
Yes.
relevant to a lot of people. So something for us to keep in mind. So our next question, we've talked about the court process, what that would look like. And Amy, I'm wondering if you would be able to share some options that are available outside of going to court.
Absolutely. And the majority of civil claims, so things that it's types of lawsuits that are not criminal, the majority of those will settle before you get to trial. And that's true in estate litigation as well. And it's something that I always encourage in my practice. And there's a number of reasons for it. So often what happens is you start the lawsuit, you set out what the positions are, maybe you'll do some exchange of documents or some examinations asking the other person questions under oath. The lawyer would ask the questions and the party would answer. And then maybe you'll move to a mediation. And mediation in estate litigation makes a lot of sense in my view. And there's lots of reasons for it. One is the cost. The cost of proceeding to trial can be very, very expensive. It can cost tens of thousands of dollars. It can cost more than $100,000. And depending on how long and how complicated it is, it could be even more than that. And so there's a lot of legal fees and other costs that are going to be incurred in your lawsuit itself. And that can be prohibitive and could stop you from being able to proceed. So there's cost, but cost is not always measured in money. And one of the big costs here is relationships, because oftentimes what happens in estate litigation is that the dispute starts or comes to a head after one of your loved ones has just died. And so you're dealing with that death and you're not really able to process the grief and move through and move forward because you're trapped in this litigation and you're fighting oftentimes with your siblings or with other family members and breaking the relationships. It may be that the relationships weren't strong to begin with, but I have not seen a case where after a lawsuit, the relationship, or during a lawsuit, the relationship gets stronger. That doesn't really happen when you're fighting with somebody. And there's a significant cost to that. And it may be the longer that you move down through litigation, the farther apart the parties are going to become and the bigger the gap between you is going to get, so that there cannot be a bridge even later after the litigation has ended, that you might not be able to reconnect with your family. And that can be a very significant effect. And maybe you've never been close with your siblings, and that doesn't seem like a big concern to you. But remember, what often happens when you're having these family disputes is that extended family, so your cousins or your aunts or your uncles and family friends, often sometimes feel that they're obliged to take a side. And so sometimes that rift between you and your sibling might grow and grow, and it might divide the entire family in half. And it might, and maybe not divide it in half so that there's no bridges, but certainly there'll be a chilling effect. So that's a really significant cost, the cost of family. And the third cost that I have, I want people to understand, is that there is a significant amount of stress that comes with litigation, because there's no certainty really until you get to the end of the day. And even then you might not get the decision that you like. And while you're dealing with the loss of your loved one, dealing with the stress and the fractures within the family, dealing with the legal costs, you're under a lot of stress, and it's a very difficult way to live, and it can interfere with other aspects of your life. So litigation is very difficult, and I do not recommend it lightly. I always recommend, almost always recommend, that you go to a mediation. And what mediation is the lawyers and the parties get together in a room, or nowadays on Zoom with the pandemic and the way that things are, we can do mediations on Zoom. And you try to together work out a resolution. So there's no finding of fact as to who's right and who's wrong. It's, can we reach an agreement that everybody will sign off on to end the matters and divide the assets in whatever way you agree to. So unlike trial, you have the power to say yes or no to the end of the day deal, right? When you go to a trial, the judge will tell you what the result is. When you go to a mediation, you get to say, yes, that's a deal I can accept, or no, there's not. I can't accept that deal. So mediation is absolutely something that I recommend, and hopefully you can do it early enough that those fractures within the family are not so pronounced that you won't be able to reconnect with your family later. So that's that's a really important consideration. And just because you start a lawsuit doesn't mean that it goes straight to trial. You've got time to try to resolve things in a more cooperative manner.
Fabulous. Thank you so much, Amy. And this piece of it especially is, I think, really important to hear from you, because you have seen the inside of so many of these types of disputes. Most of us have not. And you've highlighted not just the economic cost of running a full trial, which is very expensive and prohibitive for a lot of people, but also the relationships, trying to preserve the integrity of the family relationship, not just the immediate parties, but everybody else who's impacted. And finally, the stress of litigation, which is, as you described, this is uncertain process. And just a follow-up question, in terms of your experience, you've had parties that go through mediation, you have the parties that go through litigation. What have you noticed in terms of, or I don't know if you can comment on this, but the aftermath of either process, if one seems to have a different impact than the other?
Especially with mediation. In fact, Zach and I did mediation, I think it was 2 Tuesdays ago, and we went, I think we didn't finish till 11:45 at midnight. And it was a long day on Zoom. It was on Zoom. But we were able to resolve it, and we were able to pull in solutions that the court wasn't able to order, because the parties can agree to a lot of different things that maybe the court can't technically order, but are still good and fair in those circumstances. So when we're able to do that and we're able to tailor a solution, I think that the parties feel a good sense of relief and feel like the solution really fits. That being said, obviously, if somebody proceeds to trial and is successful, then there's that relief as well. So it's hard to say in all the circumstances, but that piece about being able to craft a solution and have a piece in that, and have the parties themselves are active participants in the solution, is quite an empowering piece. And so that's one of the reasons I like mediation a lot.
Super. Thank you so much, Amy. One final question before we turn to our live Q&A. And Zach, we just talked about some of the out of court options. What can we do? What can you do now to prevent a fight after somebody has gone?
Right. So the number one piece of advice I would give to anyone who was contemplating leaving an unequal amount to either their children, or to disinherit someone, or to, if they, usually people have a good sense of their beneficiaries' reactions in the gifts that they're going to leave. And if they anticipate that a fight is looming, the advice I would give is to talk to your family members in advance about what it is that you're going to be doing in your will. I think that oftentimes the surprise of reading in the will for the first time might cause a reaction, a negative reaction that would perhaps move you towards, children would be moved towards litigation. And I think that's primarily arising out of their not knowing why it is that they were treated differently in a will. So the number one advice is to talk to your loved ones about your wishes, so that they really understand before your death why particular way, and that provides them the opportunity to ask questions and really understand your intentions, your wishes, and the reasoning behind these decisions. I think that that will be a very difficult, and oftentimes is a very difficult conversation to have, but it is just so important to stave off expensive and emotionally tolling litigation, as Amy just talked about. If you are certain that you wish individuals, your family members, in an unequal way or to disinherit someone entirely, you should be aware that there's a number of tools available to estate planning lawyers who can help give effect to those wishes and reduce the likelihood of a successful challenge after your passing. And that's a little bit out of scope for this presentation, but some of the tools that are available might be using joint tenancy for real estate to help pass assets outside of your estate, or using more complex tools like trusts to, again, move assets out of your estate and into a structure that cannot be challenged by wills variation. And that's an important feature I should mention. Wills variation claims the assets that the court has the ability to redistribute in editing the will is really just the assets that fall into your estate. If you have given away items during your lifetime or have allowed the assets to pass by another method other than through your will, those assets may not be available to be redistributed by the court. And so again, estate planning lawyers have a variety of tools available to minimize the assets that remain inside your estate, and they may be able to, you may have greater certainty in knowing that your assets will pass to your intended beneficiaries and will not be, or will likely not be, subjected to a variation claim.
Super. Thank you so much, Zach. It's an excellent answer. There was a bit of a delay on my screen, so I'll just briefly recap for anybody who had some tech glitches like I did. But it sounds like, number one, if you intend to treat anybody unequally, for example, or a situation that might give rise to one of these types of claims, to have a conversation ahead of time, recognizing that that conversation may be very difficult to have in person, but that may spare even more difficult conversations or difficult circumstances that follow. And finally, if that is something that is contemplated in the planning stage, to consider what options are available to create that type of planning, including disposing of assets outside of the will so that they would not be vulnerable to the wills variation type of claim. So thank you so much. We are going to now turn to the live Q&A. So I'm going to stop sharing my screen. That allows me to see the Q&As that are coming in. And we're going to start with a question that came in by email right prior to our webinar. So the first question is this, and Amy, I believe you'll be handling this question. My mother's will leaves her estate to be divided equally between her 4 adult children. My sister, under a power of attorney, has sold Mom's house, moved her into a care home, and has taken a significant amount of money, half of what the house sold for, out of her account. In her words, this doesn't count as the estate because Mom's not dead yet. I've contacted the public guardian and trustee who says they don't see anything amiss. What can I do?
So that's a circumstance that happens sometimes when the mom becomes perhaps a little bit vulnerable or she needs some assistance. It's not uncommon to ask one of your children to act as your attorney. But you have to remember, when you're acting as an attorney, you must only act in the parent's or the person's best interest. You can't act in your own best interest. In this case, I don't know whether or not mom still has enough capacity, if she is mentally there still, if she has enough capacity to bring a lawsuit on her own to bring that money back into the estate. I don't know why the sister brought the money out of the estate, took half the money for herself. It may be that she says mom gave her a gift. Well, the question is, did mom have the capacity, the mental capacity to make that gift? And so that's a question that you would have to ask. It may be that she did not. And in that case, either the mom, if she's capable of doing so, can sue now, or you could get a substitute decision maker appointed for mom, which is called a committee. Or if you wait until the end of the day after mom passes, there might be a different type of challenge, which is called a resulting trust claim, which will effectively, if it's successful, force that sister to put the money back into the estate so that it can be divided. So it's going to depend what steps you would take on, number one, is mom still capable Does she have the mental capacity to bring the lawsuit on her own? Number two, did mom have the mental capacity to make a gift, and did she truly make it? And number three, do you want to do that now during mom's lifetime, or is that something that's going to be sorted out after death, depending on a number of circumstances and how much time you're going to have to do that? So it's not uncommon, but just because steps are taken during the lifetime, that means that it doesn't come into the estate, doesn't mean there isn't a way to challenge it later. It's a different type of claim and it can be challenged.
Okay, thank you very much, Amy. I'm going to ask another question that came in before the webinar, and then we'll turn to the live Q&A, which I understand is also a question that comes up quite commonly. I've lived with my common law spouse for 6 years in a home he purchased. His will was prepared before we got together and provides that his assets will be divided equally among his 3 adult children. If he passes away, will the home go to his children? What about the household items that we purchased together?
So as a common law spouse, if you are not included in the will, then you do have standing. You do have the right to challenge it in a wills variation claim and ask the court to rewrite the will. And so in this circumstance, it seems likely that you would be able to do so. And so it may be that you would get a share of the house. I don't know if you'd get the whole house. It would depend on what the other assets were and what the other circumstances were. One of the other pieces here is, what about those household items? I think the household items is a question that can be quite contentious. A lot of times it is. But if you're purchasing items or sharing in the purchase of those so that you and your spouse are owning them together, you could argue that you are owning them in joint tenancy, which means that they come to you on the death. One thing I want you to understand, and I think a lot of people are quite surprised, is that the resale value for most household furnishings is quite low. There isn't a big market for it, and there isn't a lot of money in it. So, I mean, unless you have valuable artwork or valuable antiques, while it will cost a lot of money to replace that and buy yourself a whole new furniture for your whole house, the amount that you would get on a sale is not going to be anywhere near enough to replace all that furniture. So just keep that in mind when you're talking about resolving and finding a way to work together, is that if you look at the actual value of that property in a money sense and a dollar sense, then maybe you would be more willing to allow the person to have it, subject of course to family heirlooms and those sorts of things.
Absolutely. Sage words. Wonderful. Thank you so much, Amy. Now I'm going to turn to our most popular live Q&A. And Zach, I see that you've rejoined us. So I'm not sure if you want to take this one, but I'll read it out. If the court finds that there was undue influence, would the entire will be set aside, or just the questionable portion of the will, i.e. can a portion of the will be severed?
I will attempt to answer that, and then maybe Amy will jump in if I have missed anything. I think that it does depend on the specific will that is in issue, because it is possible to make amendments to a pre-existing will. So not all wills are simply drafted from scratch every time. You can make minor amendments or adjustments to a pre-existing will just by handwriting on top of it. So in that circumstance, perhaps I can imagine a situation where just the newly added portion, if it was found to have been extracted through undue influence, might be set aside, and perhaps the original will without those handwritten additions might continue to be the will that speaks for the deceased. But if we're talking about a scenario where an entirely new will is created from scratch, and the circumstances surrounding the creation of that document is one of undue influence, I think it likely that the entire document is in question and will likely be set aside, simply because the basis for the individual even going to meet the lawyer may be in question.
Interesting. And quick question: if that were to happen, if the entire will were to be set aside, what would it be? The previous will that would be applicable, or how would that work?
Correct. So if there is a previous will that was completed, like executed with all the proper formalities, and there's no question that it was created during the point in time where the deceased had full capacity and did so, out of their own, the will reflects their actual wishes, that is the will that would likely stand and speak for them on their death. And if they didn't have a will, then the British Columbia legislation, we have legislation that describes how someone's estate is distributed. So it could be, yes, either back to a previous fully valid will, or it could be a situation where no will is in place for this individual and it will be distributed according to the legislation.
Fabulous. Thank you, Zach. And Amy, I see you nodding your head. Do you have anything to add?
Nope, that just, the situation where there is no will, that's the intestacy situation that Zach mentioned earlier. So I know lots of people hear the word intestacy and are not 100% sure on what it is, and that's exactly what it is what Zach just described.
Exactly, and the WESA, Wills Estate Succession Act, provides for that structure in terms of who inherits in what order. So we're getting close to 1 o'clock. So what I'm planning to do, I'm going to ask, I think we have time for 1 or 2 more questions. So I'll start with the first one and then we will wrap up. So this question is, can children from a first marriage challenge property left to a spouse if that property is under a joint tenancy? Amy, would you like to take this, or Zach?
Sure, I can answer that. This goes back to that same concept of a resulting trust that I spoke about with the power of attorney, when the person who was acting under that power of attorney took assets during the lifetime. And I said that you might be able to get them back because she was holding them on what we call a resulting trust. And what that means is that even though it's technically in your name, you don't own the beneficial value of it. And so you may have that circumstance here where you have a spouse who receives the house under a joint tenancy, but there may be some significant hurdles to that because of some specific legal presumptions that are in place. The presumption that, in fact, if the two of them spouses are holding it in joint tenancy, it may be that they intended to have the right of survivorship, which means they would get the whole of it. So you may have a claim. There are some routes that you could look at, but it will depend on your circumstances, whether you'll be successful.
Thank you so much, Amy. So I'm going to squeeze one last question in. Zach, I'm not sure if you'd like to take this one. I'm just going to ask the first part of it, which is, read the will's variation. Does the court take into account what the will maker gave to those individuals outside of the will, i.e. through life insurance, plan designations, joint tenancy on house, etc.? I'm actually going to jump in and I'm going to expand. If there are many assets outside the will, again, life insurance, real property, and joint tenancies, RSPs, and not many assets inside the will passing through the estate, and a will maker leaves everything to their second spouse and nothing to their kids, would the court potentially give the kids everything passing through the will in order to slightly balance out everything that passed outside of the estate?
Okay, I can attempt to answer that question. And that's a great question, actually. That would be, that situation might arise where someone has put a great deal of planning into their estate and perhaps disinheriting or treating individuals unequally. So the answer to the first question is, will the court consider the assets that pass outside of the estate through all those mechanisms that were mentioned there? And the answer is yes. The court will consider the value that pass, and that is perhaps highlights where the inequity or unequal treatment arises. Just because the court recognizes those amounts that pass to those individuals outside of the estate, however, doesn't necessarily mean that those assets are returned to the estate, as Amy talked about, in a resulting trust situation. They may not be available to be redistributed to the individuals who have a valid will's variation claim. And so I think the second question there was, if there's a minimal amount left in the estate, will everything be provided to the children? And as Amy mentioned, I don't know if we have enough facts to actually say if that will be the case, but it is certainly, I think, a possible solution if a spouse, for example, receives many assets outside of the estate and the children receive nothing but are disinherited entirely and there's just a little bit left in the estate, there might be an argument for what is in the estate to be redistributed to those who have been disinherited.
Super. And I'm going to ask one final question because it's quite related to this topic, which is if you are planning this type of estate where there is an imbalance, the question here is to avoid a wills variation claim, if excluding someone from your estate, is it recommended to specify why that person is excluded? So is that something that is recommended at the planning stage?
That's something that there is a division in the estate bar as to whether or not it's recommended. And so some people think that they're helpful and some people think that they're not. And so you're the person who's drafting it. I would rely, if you rely on them for your advice, then take their advice. But my concern with having that is unless that is 100% accurate, not just when it's drafted, but still holds true at the time of death. If it's not factually correct, the court is going to be quite likely or likely to vary the will. So unless you're 100% correct, you might be opening up a can of worms.
Fabulous. I didn't realize it was a contentious question. So that's I'm delighted that you've answered that. Thank you so much, Amy. So with that, we are going to conclude the live Q&A. I'd like to thank Amy and Zach. You have both been amazing. It's been so interesting. Thank you. Delighted to have you. And before we, I'm going to reshare my screen and put some information up on a slide. Before we do that, I would just like to ask if there's any sort of final words of your own that you'd like to share in conclusion of today's webinar.
I'd just like, again, to thank you for inviting us. Thank you for coming. I'm sorry we weren't able to get to all the questions, but these are the overarching principles, and it's difficult to give a certain answer when we don't have all of the facts. But estate litigation is an important process. It can correct unfairnesses, and if you are able to, if you find yourself in litigation, if you are able to proceed to a mediation, that's what I would recommend.
Super. Thank you so much, Amy. And Zach?
Nothing further, just thank you, Paula. Thank you, People's Law School, for putting this on. I hope that we were able to provide some information and value to the attendees. Thank you all to everyone who, thank you to everyone who attended.
So with that, I think we will call it a day. Thank you again, Amy and Zach. It was such a pleasure having you here. Thank you so much.